If you're considering divorce and your spouse refuses to cooperate, you can still apply on your own. Hi, I'm Doheny, a family lawyer at Turnbull Hill Lawyers. A sole divorce application is where one spouse applies to the court to legally end the marriage without the other spouse joining the application. Unlike a joint application, the applicant is responsible for the entire process, including filing the application, paying the filing fee, arranging service of documents, and satisfying the court that the marriage has ended. Under the Family Law Act, the only ground for divorce in Australia is an irretrievable breakdown of the marriage. This is usually established by showing the parties have been separated for at least 12 months and 1 day, with no reasonable likelihood of reconciliation. To apply, you must be legally married and meet the eligibility requirements, including that you have been separated for the required period. At least one spouse must also be an Australian citizen, a permanent resident, or regard Australia as their home and intend to live here indefinitely. You'll need a copy of your marriage certificate. If you have been separated while living under the same roof for part or all of that period, you may still apply, but you will likely need to file an affidavit explaining the circumstances. Sole divorce applications are filed online through the Commonwealth Courts portal. You will need to provide your personal details, marriage details, and information about any children under the age of 18. If your marriage certificate is not in English, it must be translated and supported by an affidavit. Once the application is prepared, it is filed with the court and a filing fee applies, although reduced fees may be available in some circumstances. A critical step in a sole application is serving the divorce papers on your spouse. Your spouse must be served at least 28 days before the hearing if they are in Australia, or 42 days before the hearing if they are overseas. You cannot serve the documents yourself. Service must be carried out by another person, such as a friend, family member, or professional process server. The court will also require an affidavit of service to confirm service has occurred properly. Depending on your circumstances, you may be required to attend the divorce hearing, particularly where there are children under the age of 18. Where your spouse files a response opposing the divorce, or where you need to apply for substituted service or dispensation of service because you cannot locate your spouse. Your spouse does not need to sign the divorce application for the process to proceed. However, they must be served and have the opportunity to respond. If they oppose the divorce, they generally must show that the required separation period has not been met or that the court does not have jurisdiction to deal with the application. If the court is satisfied that all requirements have been met, it will make a divorce order. The divorce becomes final 1 month and 1 day after the order is made. Once final, you are legally divorced and may remarry. However, it is important not to make wedding arrangements until the divorce has been finalised. It is important to remember that divorce does not automatically resolve property settlement, financial matters, or parenting arrangements. In most cases, you have 12 months from the date the divorce becomes final to commence court proceedings for property settlement or spousal maintenance, if required. A sole divorce application can be straightforward, but mistakes with filing, service, or supporting affidavits can cause delays. If you need help with your sole divorce application or advice relating about property or parenting arrangements, contact Turnbull Hill Lawyers and speak with our family law team.